party to the contract. So, the behavior of the manifesto material. Due to this fact, we know that the letter of credit was opened by the manifesto material. We have them, it is proved by the case materials. And so, we are aware of the fact that the buyer is a guarantee of the respondent. You can see this fact on the page 15 of the shipbuilding contract, on the case materials.
We have 1 minute.
Okay, I will finish. And okay, here you can see that there is a guarantee that is granted by the buyer. Due to this fact, we see that the buyer is responsible for the action of the of the bank. So by this fact, by this dealing, we can say that there is a gross disparity between the parties. And due to this fact, we understand that this clause 3.2.8 of the general principle is applicable to us. If it is applicable to us, we state that also the provision of shipbuilding contract that is included there for arbitration procedure is also applicable to respondent. And as we know that in the shipbuilding contract there is a clause 10.1.2 where is arbitration clause. So due to this fact, we assure that this arbitration clause is also applicable for respondent.
Thank you. Respondent, you have 2 minutes for rebuttal.
Thank you very much. The claimant asked not to pay attention on the respondent's answer on the claims. Respondent states that it will be a violation of our rights. The second, that the party of the second arbitration is different, we agree, but we have the same contractual relations. I say about the relation of the acceptance act. Second, the claimant's counsel stated that for Article 10.1.1 of the shipbuilding contract have meaning in this case, but the respondent states that the letter of credit doesn't have any relation to the shipbuilding contract, and that is why the respondent states that these proceedings cannot be grounded by the best principle of international trade law, and that is why the claimant cannot use the neutral principles to prove the position. And last, the claimant states that the respondent sought their shipbuilding contract when the respondent opened their letter of credit, but the respondent don't have such obligation, and according to the Russian arbitral practice of the 15th of January 1991, their bank don't have such obligation. And I have a question to the claimant. Can I ask?
I think it's not permitted under the rules.
Okay, I'm done. Thanks.
Thank you.
Yeah, first of all, I want to start with the fact that the requirement that stated by the respondent about the same parties, same subject and etc. Are not met. As I already stated, I don't want to repeat my claim and my arguments on this point. The second point that I want to state here is that the claimant stated that the general principle is not applicable for us. Unfortunately, I don't know, but maybe it is not aware of the Article 10.1.1, I can read for you, if it's possible, that the parties hereto agree that the validity and interpretation of the contract of each article and part thereof shall be governed by the best principles of international law. I think it is not necessary to prove that Union Principle 2010 is part of best principle of international law. And the last point that I want to mention, why the claimant is using the Russian arbitration practice. We are not aware that the Central-Stan or Zapistan is under Russian law. Okay, and so...
Excuse me, Counsel, and so you state that if your jurisdiction is not under the Russian law, with the present tribunal we cannot apply the Russian arbitration cases?
No, you can, of course you can.
For your consideration.
Yes, but I think it's necessary to prove that these rules are applicable here and that they including also in the best principle of international trade law. I think so, but it's of course it's for consideration of the panel of arbitrators. And due to this fact, I want to claim that in the conclusion of this rebuttal, I want to say that the arbitration clause, due to the already mentioned position, is extended to the respondent, and the second point that the arbitration proceedings shouldn't be suspended.
Thank you. Now we may proceed to the material part.
Thank you.
James, will you start?
Thank you very much. Good morning, dear members of the arbitration panel. My name is Artur Bereza, and I will present the plaintiff in these hearings. That will be Lex Mercatoria. Today, my main goal is to prove that on the 7th of March, Lex Mercatoria conducted a proper presentation of the documents for payment. My speech will consist of three main parts. The first part would be the condition of providing safety certificate is unwritten according to the terms of the letter of credit. The second part is that the act of acceptance was presented properly. And the third part that logically comes from the previous two is that all the claims of Lex Mercatoria should be fulfilled on the terms of full indemnity. So let me proceed to the first part. The ship safety certificate is not properly completed and duly executed in the view of lack of reference to the person to who it is competent to issue such document, and the reference to the country on the territory of which it must be issued. I'd like to draw your attention to the Article 14H of the UCP 600, quote, if a credit contains a condition without stipulating the document to indicate compliance with the condition, banks will deem such condition as not stated and will disregard it. Due to the good business practice, the practical work of the certification of the means of transport should be done by the specific certification bodies. And Lex Mercatoria does not have a certification for doing such work. And besides, in accordance with the provision of shipbuilding contract, there is no agreement between Lex Mercatoria and the other party, that would be Mr. Evazov and Manifest Ltd, that such certificate should be provided by the claimant. Let me proceed to my second part, that the act of acceptance of yacht was presented properly. The bank, I'd like to draw your attention to page 28 of the case material. Here we have the act of acceptance. According to paragraph 3 of UCP 600, a document may be signed by handwriting, facsimile signature, perforated signature, stamp symbol, or any other mechanical or electronic method of authentication. Thus, the seal and the handwritten signature on the act of acceptance are sufficient conditions to meet the requirements for the document's signature. The bank is not responsible for verifying the correctness and completeness of the documents in the letter of credit. As stated in the Article 3, a requirement for a document to be legalized, certified or similar will be satisfied by any signature, mark, stamp or label on the document which appears to satisfy the requirement. The bank has no qualification for verifying signatures, stamps and etc. According to Article 1, Article 17, sorry, paragraph B, the bank should consider any document to be original if it contains apparently original signature and stamp of a person who issued the document. All this proves that the act of acceptance was presented properly, and the bank should take it as it is. I'd like to draw your attention to page 22, I'm sorry, 20 of case material, where all the documents that should be presented according to the terms of the letter of credit are listed. It states that we need to present seven documents, but we've already proved that National Passenger Ship Safety Certificate should not be provided, which means that we should have presented 6 documents, and that's what we did on the 7th of March.
So may I ask
yes.
a question? Under the UCP 600, the bank is not bound by the main contract. Could you comment on that?
Yes, but that's the letter of credit. It's not the main contract.
Yes, well, you state that the letter of credit, although it states that the ship safety certificate must be provided for fulfillment of the payment. You state that even though it was not provided, the bank should effect payment.
No, I stated that according to UCP 600, the letter of credit should have evidence who should sign this, who should issue the safety certificate, and if there are not, if such conditions are not met, banks should disregard this and think that this paragraph 1.7 should consider it as unwritten.
Yes, but according to the case materials, this certificate was not presented to the bank. And
Which means that we shouldn't provide it.
Yes, but because due to the UCP 600, we consider this condition of the letter of credit as unwritten, so we don't need to provide the document that is unwritten in the letter of credit, because we already, as my colleague has already proved, that if the condition is not hasn't met the requirements, we need to consider this document as not written in the list of documents that is in the letter of credit. Because of it,
yes, I would like to repeat once again Article 14.h. If a credit contains a condition without stipulating the document to indicate compliance with the condition, here we don't have any conditions about compliance. The banks will deem such condition as not stated and will disregard it. That's what we are trying to prove. We believe that all the conditions of the letter of credit were met. The presentation of the documents was fulfilled properly. Therefore, we believe that on the 10th of March, the bank unlawfully disregarded our payment. I'd like to disregard our request. I'd like to draw your attention to the letter of the bank, page 31. Page 31. it states that after examination of your presentation dated 7th of March, we found out that the act of acceptance was not signed by the authorized person, but we proved that it was signed properly and presented properly. We also noticed that the National Passenger Ship Safety Certificate is missing, but we also proved that we did not need to provide it. According to UCP 16, the bank should indicate all the discrepancies between the presentation and the terms of the letter of credit. So they indicated only 2 discrepancies. But we proved that these issues are not discrepancies. And therefore they cannot ask us to provide any additional documents and to correct any other mistakes if such mistakes will occur. Therefore, the claimant respectfully requests the arbitral tribunal to issue an award ordering respondent to pay the claimant damages amounting $11 million, ordering respondent to pay the claimant interest accrued on the amount of damages of amounting to $147,620, ordering a portion award interest of the amount of damages claimed in subparagraph A above from the date of the award till the date of payment, amounting to $678 a day. Ordering the respondent to pay the legal costs amounting to $1 million. Ordering the respondent to pay the costs of the arbitral tribunal on the principal of full indemnity amounting to $120,000. Ordering the respondent to pay the administrative costs amounting to $58,515. The claimant also reserves the right to change the supplement its preliminary requirements for relief at a later stage. Thank you for your attention. I'd like to close my session.
Thank you. Respondent?
I need to say about factual circumstances in order to clarify defendant's position. On 7th March, the claimant made presentation to the respondent under the letter of credit and requested to effective payment of the remaining 50% of the necessary sum. The respondent immediately informed the buyer of the fact provided to effective payment, that copies and received documents, and stated that it was planning to effect payment of the credit under letter of credit within the next 3 days. But new circumstances arise. On 10th March 2016, the respondent issuing bank, in this case, refused to effect payment of the credit under letter of credit to the claimant. First, the claimant was obliged to present ship safety certificate in order to obtain payment under letter of credit and failed to perform its obligations. Thus, its request for payment has been rightfully rejected. I need to make reference into an international document in accordance with the regulation number 12, paragraph 7 in part B of the SOLAS 74. Passenger ship safety certificate shall be issued either by the administration or by any person or organization duly authorized by it. In every case, that administration assumes full responsibility for the certificate. We know that the claimant was obliged to provide all necessary documents, including ship safety certificate. Second, the bar representative, Mr. Abazov, didn't sign the Acceptance Act. Thus, the claimant again failed to comply with the requirements of the letter of credit to obtain the payment. The issuing bank has a credit card of Mr. Avazov, where signature of him. And if we compare the signature on this credit card and in the acceptance act, we can define that they are different.
I have a question. Do you think a person can have two different signatures?
Can you repeat?
Do you think one person can have two different signatures?
It's very difficult to ask me this question. The man shall have one signature, because if he will sign the documents by other signatures, we cannot define this it was his signature or not. Also, that the respondent issuing bank had no obligation to effect payment under the letter of credit in the amount of United States dollars. 11 million of the claimant failed to meet the established requirements. The claimant failed to make a compliant presentation under the letter of credit. Also, we have a letter of credit. It was sent by issuing bank, the respondent in this case, to the claimant, Luxiax Ltd. And you can see on the page 31, it is stated that there was examination of issuing bank. After examination, I will quote some of phrases. After examination of your presentation, we found out that acceptance act wasn't signed by the authorized representative of Manifestum Ltd. We also noticed that the National Passenger Ship Safety Certificate is missing. That was obligation of the claimant to provide it for the issuing bank. Thus, the above doesn't qualify your presentation as compliant, and we are unable to effect payment under the letter of credit. I need to pay attention on such statement that the respondent is not entitled to payment under a letter of credit. The issuing bank is an agent. The only obligation of the bank to make transfer from one party to another. And we know that the applicant, it was Mr. Avazov, and there was obligation of him to pay for the beneficiary, Luxiax Ltd, not issuing bank. Issuing bank is an agent, and issuing bank is not being considered as part of the as a party of the shipbuilding contract. The claimant failed to present to issuing bank the ship safety certificate. Its presentation 7th March 2016 cannot be qualified as a compliant one. To clarify, we need to make a refer on international document USP 600 Article 14, paragraph A. The issuing bank must examine a presentation to determine on the basis of the documents alone whether or not the documents appear on their face to continue a compliant presentation. This is an authorization of the bank to examine where presentation compliant or non-compliant. For the above reason, the claimant doesn't have any ground to claim payment under letter of credit.
Counsel, I have a question. According to paragraph 10 of the letter of credit, page 22, the LC is issued without prejudice to the shipbuilding contract, which shall have a full effect with regards to the term of this letter of credit. So, if the list of documents was written in the shipbuilding contract, wasn't the bank obliged to follow the contract and not the additional documents that were added to the letter of credit?
There is legal issue who determine what documents shall be provided. And the issuing bank, in the letter of credit, issuing bank informed the another party, the claimant, to provide necessary document. There are no any objection of the claimant to provide such document, and the issuing bank determine what documents shall be presented in order to make transfer. I need to note that the issuing bank was acting with the principle of good faith. This principle contained in the Article 14 of the United Nations Convention on the Independent Guarantees and stand by letters of credit. The issuing bank must examine documents in order to obtain its obligation. Else, one statement is that the claimant was well informed about terms of the letter of credit, and on 5th March 2016 the respondent notified the claimant that the bar opened letter of credit for the amount of 11 million United States dollars, further to the provisions of the shipbuilding contract. And another statement is that shipbuilding contract not incorporated letter of credit, because in the letter of credit we may refer on the USP 600, and USP 600 clarify that issuing bank is an agent. It's not a party, and there cannot be some objections in our statements, because we asked to lack of jurisdictions in the arbitral tribunal to consider this case. And that's all.
Can I have a final question? As a bank, do you know do you familiar with any cases or any authorities that provides that in special circumstances like that the bank has the right to demand additional documents? Just any case, if you are familiar with.
To refer on some analogical case in international book ties?
If you have. The question is, has the bank right to request additional documents that are not in the list. Contact.
Can I answer this question? We have a Russian arbitration case, Russian arbitration practice, as I told you, in January of 1999 of a Russian arbitration that the bank have no obligation